can only form a company if you are 18 years and above.
Okay.
That one, a single person can form a company. For a company, there's no maximum, but the minimum is 2. Now, in order to form a company, you have to make an application to the registrar. And in the application, you are going to provide the following information. 1, the name of the company. 2, an indication of the proposed company. Is it company limited by shares? Is it company limited by guarantee? The nature of the proposed business. In the case of a company registered with an object, so what are you going to do? What is your business? The address of the proposed registered office and the principal place of business. Where are you going to be? Where will it be the actual place that you are going to operate? The telephone number and post office box, private email, digital address, electronic mail address, websites, the particulars of each subscriber. Now, we are talking about those who will sign the application for incorporation. They are called the subscribers. You need the date and the place of birth, the present full name and any former name if they are changing names, residential, occupational, postal, and electronic mail address, telephone contacts, nationality. So you provide this information. Now you also have to provide the names of the proposed directors. Who are going to be your directors? The present full name or any former name. The particulars of any business occupation and other directorship held by the director in question.
No, sir.
Yes.
The line is breaking. I'm not getting anything. The line is breaking.
Please, are you the only person who can't hear?
The line is breaking. I'm not getting you.
I'm sure it is network. Mine is okay here.
Please, we can hear. Continue.
Yeah, the one who is complaining is your network.
Please, they should reposition themselves now.
Okay, so if you cannot hear, position yourself well. Because where I am, I'm convinced that the network is very effective. I'm on campus and my office network is working. So if you can't hear me, kindly adjust yourself. Yes.
Hello, sir.
The one who just called.
Hello.
I'm listening.
Please, we
The
can
one
hear
who
you.
just called, I'm listening. Please, those who can hear me, can
is that same person? Is that same person?
He said you can.
Sir, you can proceed.
Okay.
Yeah, we can hear you. Yeah, I'm sure it's.
Let's proceed.
Yeah.
The residential, occupational, and postal address. Now, do you understand why this information must be provided?
No.
Can someone give me a reason why this information must be provided? The residential address or occupational address. Why? Do you have any reason?
Yeah, sir, I think that they need these details to be able to trace you and to be able to know where you are. So that in case of anything, there's a way they can trace you.
That is true. Now let's proceed. You also have to provide a statutory declaration by each proposed director of the proposed company, indicating that within the preceding 5 years, the proposed director has not been charged with or convicted of a criminal offense involving fraud, dishonesty, or the person is charged with or convicted of criminal offense relating to promotion, incorporation, management of a company, or a declaration of insolvency, or if the proposed director has been insolvent, the date of insolvency, and the particulars of that company. What it means that you have to make a statement, a declaration that you have not managed any company that has gone insolvency. That means when the liability fell due, they couldn't pay and the company has collapsed. Or you yourself, you have not been charged with or convicted of criminal offense. Now, there's a case law that points to the fact that the word charged with, as you can see in H, I, and II. So this word, can you see the cursor? Please, can you see the cursor?
No, please.
No, please.
But you can see my screen.
Yes, yes, sir.
You can see my screen.
Yes.
Yes.
Yes, sir.
But you cannot see my cursor.
We can't see the case.
Yes, madam.
Okay. No problem. But you have seen point I. HI.
Yes, I.
Yes, you see that it's time for charge with.
Yes.
You see it?
Yes.
That I also
Yes.
say charge with. You say
Yes.
Yes.
Yes. Charge with
yes. There has been a case law before the Supreme Court that this phrase charge with is inconsistent with the Constitution. And therefore, that word has been declared inconsistent with the Constitution and has been deleted. But in law, when we make a pronouncement that a provision is inconsistent, you cannot go and take pen and cancel. Did you get it?
Yes, sir.
Yes, please.
Even though the word, this thing that you see here, as it stands now, it should be read as convicted of criminal offense involving dishonesty or fraud, convicted of criminal offenses relating to promotion. So this charge with, the court has made pronouncement that it is no more in existence. It is no more operative. And this was stated in the case of Derek Edwin versus Attorney General. Derek Edwin versus Attorney General. That's when the Supreme Court made that pronouncement. So we have something called the spirit of the law. Now, when you pick the act and you read it like this, you know, because you have not read that case, you will take it as it is. But as it is in the act, it is not the current position of the law. The current position is that the child weight is deleted. So when you are explaining, you can write what is there and go ahead to state that the phrase child weight has been declared as unconstitutional, and therefore it is no more operative. The reason being that in Ghana, when you are being charged with an offense, you are free as the one who has not committed any offense. But when you are convicted, it means that you have been taken through the process and you have been found guilty. But I hope you get the description, the difference.
Yeah.
So if I'm charged with, and I'm free as a person who has not been charged with any offense, then you cannot use that basis to prevent me from being a director. That is the import of this principle. You need the consent of each proposed director. And the proposed company secretary, you need the person's full name, formal name, postal address, occupational, residential address, business occupation. Then you also need the details of the proposed auditor, full name, formal name, postal and email address, residential address, telephone address, the auditor's consent. Now, we also need particulars of each of the subscribers with shares, the full name and the former name, the date and the place of birth, the telephone, nationality and proof of identity, Ghana card. Beneficial owners of the company, the full name, any former or other name, date or place of birth, telephone, nationality, and whether or not the person is politically exposed person, you have to indicate. Now, in terms of company with shares, you have to state the proposed stated capital, the authorized shares. When we say authorized shares, it is the number of shares that you are permitted to issue. Company with limited by guarantee, an amount that will be paid by the people as they have promised. You remember in that company, we said if the members must promise to pay a certain amount in the case the company is winding up. Then when this document is ready, the subscribers will sign. And they will sign, so the application shall be signed by the subscriber or each subscribers, if more than one, for shares of the company by writing opposite the name of the subscriber, the number of shares the subscriber takes, and the cash price payable for the shares, and the subscriber shall take at least one share. So when you fill it, the subscribers will sign. Once you sign, you deliver it to the registrar. The registrar will now go through. If everything is okay, you will be asked to pay a certain fee. Once you pay that fee, then the court will issue you, the registrar will issue you a certificate of incorporation. And that certificate of incorporation, once it is done, the company becomes a separate legal entity. It can seal and it can be sealed. Now, the certificate shows that the company has been fully established. The company has been fully established. Where there are omissions or errors in the document, it is the signatories to that document who will be liable. So that is it. So what we have just done is the aspects of your notes when it comes to formation of company. So you may not use this information as is stated here, but you will now fall on the one I just discussed with you. So when you get the act, you look at the information, you will place from section 12, as we have discussed, from section 12 to 14. So 12 up to 14. No, 12 up to 17. That will be placed in your manual, what we have there, as we have explained. I hope it makes sense. I hope it makes sense.
It's not clear, sir.
It's clear. I'm saying that
No.
if you look at section, unit 2, section 4, we have formation and consequences of incorporation. And I'm telling you that
yes,
the
sir.
formation, you use the act from section 12 up to section 17. And ignore what is in your manual as far as the formation is concerned. So in your manual from page, let me say from page
43.
Not 43, from page 49.
49, yeah.
49 up to this page is which number? 42, 52. By 52, the advantages are part, so you read that one. So 52, anything above the advantages, you have to go by what is in the act, the one I've explained to you. The ones in the book, they are no more in use.
Hey,
Pretty that
Say,
they're
Yes.
holding it like
please, can you please repeat it again?
Which of them? I've said a lot of things. Which of them?
Said the one that you said we should go, the pages we are mentioning, and then the one you said is no more. The one in the book is no
So
more.
when you come to, listen, when you come to Unit 2, Section 4, there are two things there: formation and consequences of incorporation. Now, if you take that topic, anything above the advantages of incorporation, throw that one away, put Section 12 up to Section 17 there.
Sir, please, where is the Section 12? Where's the Section 12?
Oh,
So,
what you said is that. I will send you the act.
Oh, okay.
That is what I took you through, but you didn't see that I was presenting something different.
Yeah, I was looking for it through in the book. I wasn't finding it.
No, you don't see it. Because I made a
Okay.
statement that the act has been changed. So when we get the section, I will let you know.
Okay, sir. Thank you.
So
Sir,
I will
sir.
tell you that. Yes.
Sir, can we please have the link, the WhatsApp link to the group? Some of us are not there yet.
The page.
Yes, sir. For
Yeah,
this
the course
particular.
work will do that.
All right, thank you.
Yeah, it's true because some of us we are not part of the WhatsApp platform
Oh,
at
we
all.
have made that. We have settled that issue that the course work should send it to you people.
Okay.
Unless you just joined. Now let's proceed. Advantages of incorporation. Now, when you incorporate your company, what are the advantages or what are the consequences? One, it becomes a separate legal entity. So, meaning that it will have separate property. The property of the company is for the company, not the owners. So, the members have no direct interest in the property of the company. They only have interest in the number of shares they hold. So, as a member or the one who formed the company, you don't have direct interest in the company, but you have interest in the shares that you have purchased. Perpetual existence and succession. This simply means that the company will continue to be in existence for the foreseeable future. And it should have at least 2 directors. If the one who formed the company died, the company must still continue or exist. Legal action. The company becomes a separate legal entity. It can sue and it can be sued. If any wrong is done to the company, it is not you who can bring action, but it is the company that can bring action. Look at the case of Force versus Haberton, Bank of West Africa versus Appleton, and Solomon v. Solomon. Now, in terms of liability, from liability, you have to take it from 3 different angles. One, it is a company limited by shares, meaning that the liabilities of the members are limited to the amount they have not paid for the share that they have received. For unlimited liability company, as the name suggests, they don't have limits on their liability. For guaranteeing, as the name suggests, the amount you yourself have promised to pay if the company is winding up, that will be your cost or your liability. In terms of borrowing, the company can borrow money because it is an artificial person. Transfer of interest. You remember that when you were explaining the difference between private company and public company, we indicated that in private company, the transfer of shares or the members' right to transfer shares are restricted. But for a public company, you can easily transfer or you are free to transfer your shares. Now, what are the disadvantages? in terms of the disadvantages, we are saying that there are too many technical formalities. The cost of formation is high. You don't have control over the business because a lot of people have shares and they also have control. Loss of privacy. You will require to disclose your income. Like unlike the private person, when he gets income, he or she keeps it. Now, how do you convert private company to public company? So you want to look at conversion of private company to a public company. If you want to do so, you have to change your constitution. Note, I didn't say one thing. It is not compulsory for every company to have constitution. There's a default constitution. So if you use the default constitution, then you don't have to have any constitution as a company. The constitution was formerly it was called regulation, but now it is called constitution. Now, if you want to convert private company to public company, what you have to do is that you convene a meeting of the board of directors and you pass a resolution that you want to convert from private to public. Now, in the general meeting, if you have constitution, you have to alter it by special resolution to give you room to make that arrangement. Then when you finish, you make application to the registrar for approval of the conversion from private company to public company. And the application should go with the requisite filing fee, your prospectus or your statement in lieu of prospectus. Then particulars of the members, the particulars of directors, secretary, any alteration relating to the provisions and fees, a copy of receipt of the fees evidencing the documents. So once you do all these things, your company will be converted from private to public, and all the rules will be applicable. I'll pause here and take a few questions. Any question?
Okay, my has to do with the fact that I didn't join the first day because we were then chasing
the first day.
Yeah, no, but I'm not taking us back. So I just want to ask if the amendment that we just went through is the only amendment so far we've done, or there were amendments
no, where there have been an amendment, I've already indicated that.
Yeah, the only one we have done so far right now. Okay.
The massive amendment you have done so far, but you have done some minor one, which I clarify in the area stage.
Wow. So I don't know if during that time that I didn't know.
No, it was not a massive amendment. It was just the sessions that changed, but the content were the same.
The same. Okay. Thank you.
Yeah, but where the content has been changed, that is where I took you to.
Okay.
Did you get it?
Yes, I get it.
Okay.
Thank you.
You're welcome. So you are now going to discuss promoters and pre-incorporation contracts. For this aspect, what is in the manual is okay, no substantial change. The only thing that has changed is the numbers, the sessions. So if you see this side, you will notice that it said promoters are defined under section 12 of Act 179. Did you say it? The definition of promoters.
Yeah.
The section has changed, but the content is the same.
Okay.
I hope you get it.
Yes, sir.
So when we come to section 13, section 10 and section 10, it tells us section 10, the new act, section 10 and 11 deals with promoters and pre-incorporation contracts. So let me take you through the act itself, okay? Hello?
Okay.
Yes,
So
please.
you can write in your book, promoters, section 10 of Act 992, of Act 992. Then we discuss. So as we are discussing, then you follow. But what is in your manual is also good. But I prefer to use the act. Now, when you talk about who a promoter is, we are saying that a promoter per section 110(1) is a person who is or has been engaged or interested in the formation of a company. So if you have been engaged or you are interested in the formation of a company, then you are a promoter. So for instance, when you want to do business or form a company, then we ask you, the one who will bring the idea is a promoter. The one who will play a role to ensure that the company is finally established, that person is also a promoter. Now, the exception to this rule is that if you are acting in your professional capacity, or a person acting in a professional capacity for persons engaged in procuring the formation of a company, is not a promoter of that company. If we engage your services when we want to form our company, then you are not a promoter because we are going to pay you off. So you, this class, you want to form a company, then you have hired me, my service as a lawyer. I am not a promoter, but the one whom you send to come and do for me is a promoter. Now, what are the duties of a promoter? A promoter stands in a fiduciary duty to the company per section 3. When we say fiduciary duty, we mean that you are in a position of what? Trust. You must also observe utmost good faith towards the company in a transaction with the company or on behalf of the company. Now, when we say utmost good faith, I know you understand. When you go to a place and you have to go and sleep at a guest house or hotel, you look at your money and you find a reasonable accommodation. When you are not the one going to incur the cost, you just pick any accommodation of your choice. It's bad faith. Another duty is to compensate the company for any loss the company will suffer by reason that you, the promoter, has failed to observe utmost good faith. It is your duty as a promoter to render an account to the company if you have obtained information or property which you should have acquired or used the information to the benefit of the company, but you use it for your personal benefit. Any profit that will come out of it, you have to give it to the company. Now, that is
Hello?
Yes.
Please, the first point, the fiduciary relationship. Can you take that one again? I didn't get it well.
I'm saying that means that you are in a position of trust. Someone has entrusted something in your hand, and you don't have to make secret profit, take bribe, all those things are parts.
Okay.
Okay. I hope you get it. Now let's see pre-incorporation contracts. When we talk about pre-incorporation contracts, we are looking at the contract that you enter on behalf of the company before the company is finally established. That is what you call pre-incorporation contracts. Any company that you enter on behalf of the company before the company is established, it is called pre-incorporation contracts. Now, Section 11 provides that a contract or any other transaction purporting to be entered into by a company before the formation of the company or by a person on behalf of the company before its formation may be ratified by the company within 18 months after the formation of the company. So when you enter into pre-incorporation contracts, you can, when the company is formed, the company may decide to ratify, meaning that accept the contract as if it was in existence at the time of the contract and pay the liabilities, and if there's any benefit, the company will bear same. Now, when the company ratify, when the company accept the responsibility, if there's any profit attached to or any benefit attached to that contract, it is the company who is going to enjoy. And if there's any liability, it is the company that is any liability is the company that is going to incur. Now, before the ratification, the company can ratify or may have the capacity to ratify the transaction if it was entered into that contract in the name of that company. So when you are entering, you use the company's name, even though it is not in existence. And once it comes to existence, it will decide to ratify within 18 days. If you don't do it in the company's name, the company cannot ratify. Now, it used to be the position under common law that pre-incorporation contracts cannot be ratified. And their reason was that if the company is not in existence, how come it can ratify a contract that was entered when it was not in existence if it is finally ratified? So the common law does not permit ratification of pre-incorporation. Look at Kenneth versus Baxter. So that's why I said that the information in your notes are accurate. But Section 11 has paved way that the company can still ratify even when it's not in existence. So that is it. But who can ratificate? Who can do the ratification? What are the factors that the promoters must do before they can ratify? Now, if the promoters enter into transaction, I'm reading in Section 10.5, condition that you have to meet before the pre-incorporation contract can be ratified. If the company wants to ratify that contract, the promoters must give full information about the contract, and the board of directors or all the members of the company or the company at general meeting can decide to ratify that contract. So basically, that is what we have under promoters and pre-incorporation contract. Promoters and pre-incorporation contracts. So when it comes to this session, the information there are accurate, except to say that the sessions are not the same. So you may read it and contrast with the one with the act. But virtually, that is the same thing that we have discussed. So that is it, unless someone has a question. Any question? Any question?
Hello, sir.
Yes.
Yeah, I just want to know that for the purpose of examination sake, which one should we consider? Refer to, is it the model or the act given to us by you?
They are the same thing. Just that it is a section. If you are making reference to the numbers, you have to use the new numbers.
All right, sir.
But if you don't want to make reference and you want to use the substance only, you can use the manual.
Okay, sir.
First, I want to show that you have learned some law. Say section 10 defines promoters as so. Then you add, but you can also decide that the promoters are defined as so without bringing the sections. But it's relevant for you to know the sections per the new, so that the server will know that you're also talking about. Now the next topic will be veil of incorporation. The veil of incorporation and ultra virus. Can you give me 5 minutes? I will join you. But I'm so give me. I want to visit the private, the washroom. 5 minutes, I will join you.
Okay.
Okay.
Hello, colleagues. Help me out. I just joined. My phone went off. I just joined. Which unit are you?
Please, I've sent the link here, so you can go and the WhatsApp group link. It's here, so you can just
Unit
go and
2,
tap on it.
section 6.
Thank you.
Go to page 63 in section 6, unit 2, page 63.
Please, where did you share the thing? The WhatsApp link. Where did you share it?
I believe it's in in-call messages, just where we are. Tap the 3 dots and check in-call. You see the link.
Okay, okay.
I think that's where she has done.
Hello.
Please, madam, we can't hear.
Hello. Say we should give us a minute so he'll join us. So let's wait for him, please.
It's a sir, not a madam.
Please, those who are not in the group can go and click on the link. The dev has posted it on.
Hello. Hello. Please, I'm back.
All right,
So,
welcome
Yes,
back.
sir.
Okay, thank you.
yeah, okay.
Now let's
Welcome back, sir. You can proceed.
we are looking at the veil of incorporation and ultra virus. This session we are dealing with two elements. So let's proceed. The information here are also intact, subject to few changing. When you get there, I'll tell you. Now let's start with the veil of incorporation. With veil of incorporation, you should understand it from the point that when you register your company becomes what? A separate legal entity. That is the first point that you have to note. Because the company is a separate legal entity, the liability of the company cannot be slapped on the officers working for the company. So if ABC company has Amma Adwa as 8 employees, when Amma Adwa enter into transaction, it is the company that is responsible. And this has been declared in the case of Solomon v. Solomon. Please, you have to read the cases. And the Ghanaian version of this Solomon v. Solomon is what you call the Monko Bukuma case. Now, in a Monko Bukuma case, the court held that once a company is registered, it was restricted by its constitution, the parent constitution, as is used to be the regulation. And it will have all the powers of a natural person. That means it can seal in his own name and it can be sealed. So that is the foundation. Now, the corporate veil is a figurative veil that separates the corporation from the persons working or controlling the company. So it is that veil that protects the officers who are working for the company so that they will not be personally be liable. Remember, it is not a church wedding veil. It is the veil that protects the officers from being liable when they are acting for the company. Now, the corporate veil serves as what? A barrier between the company and the officers for the officers being personally liable. And this was heard in the celebrated case of Solomon v. Solomon. Let me give you a brief of Solomon v. Solomon. You have to read the full story, which is in the book. Mr. Solomon formed a company, and himself and the family were shareholders. He took loan from people. Initially, he was operating as a sole proprietor, as a boot manufacturer, and he converted it to company. Now, when he converted it to company, he sold his property to the company as shares and took loan from others. The company went into liquidation, And Mr. Solomon sold the property of the company or the residuals to pay himself, and he failed to pay the creditors. The creditors went to court that you, Mr. Solomon, you from the company, so if there's anything, we should settle aspect before you look at yourself. Mr. Solomon said, no, I am different from the company, and therefore I have to be paid first. The court held that Mr. Solomon is separate from the company. So when you read the full story, you get the import. The case established that the one who formed the company is different from the company. Now, we have established that the company, the officers working for the company are not personally liable. There are instances in which the court can make you liable, or you be held liable, not the company. And this is what you call lifting the veil. Lifting the veil. So when we lift the veil, there are three ways in which the veil can be lifted. By the Companies Act 2019, Act 992. So this one, the 1963 that you see, Council it and Right 2019. Please, you get it?
Yes, sir.
No, please come in.
Oh, why would this one to say you don't understand? I'm just saying that the 2019 here, Council it and Right, the 1963 year, Council it and Right 2019. Because that is the new act.
Okay.
I have a personal book on it, but because code, they don't sell books to students. That is why I'm not able to show you that book. And I'm showing you the art itself. Because if I show you this book, I have to send the book to you. Which will also create confusion. So I decided to guide you through the act so that you find it easy. Now let's proceed. Now let's look at lifting the veil pursuant to the act. It means that there are certain things in the act that help us to understand that under certain circumstances, the company will not be liable, by certain people will be liable. So for instance, where a company carries on business for more than 6 months without any member, so this position has been changed. Let me see if I can use here. There are lots of changes here. So let me show you different points. But I will direct you as well, you should look for. You understand? Hello? Why you are watching, because
Yes,
of the
sir.
nature of it, it's a little bit confusion. It is confusing. But you should also collaborate with me as I try to find a good ground for you.
Okay.
So let me see if I've done it somewhere. I want to use that one to explain certain things to you. And as I don't say it, I'm sure I will say it. Okay, so since I've seen it somewhere. I think that was the exact place I opened. So let's use my book to discuss, and I will show you where the provisions are. You people should contact the SIC that the company law book that you are using, you are finding it challenging. They should go to management.
Okay, sir.
So let's discuss. Do you pay for the manual?
Yes, sir.
Yes, it's included in our fees.
Oh,
You don't pay.
No, please. No, we don't pay. It's included in our fees, so.
It's included in our fees.
Let's proceed then. So these are the ways in which the pay can be lifted. One, if at any time, I hope you can see my screen.
Yes.
Hello?
Yes, please.
Yes.
yeah, we can see this.
Yes, please. We can see your screen.
So write section 41 of Act 992 so that if I send you the act, you check. Section 41 of Act 992. Section 41. Are you there?
You've done that, sir.
Yes,
Have
sir.
you written it?
Yes, sir.
Okay, so
Yes, we are.
I'll take you to the act and point what I was
Is
referring
breaking. The
to.
line is breaking.
Come again.
Section 41 Act.
What did you say? I said section 41 of Act 992. I'm not hearing you.
I believe it's
It's your phone or network check. So let's look at this provision. Can you see my screen?
Is the phone?
Can you see my screen?
Yes, so we can see.
So 41 reads.
Yes, we can see your screen, sir.
41 reads, if at any time a company ceases to have a member and it carries on business without at least one member, every person who is a director of the company during the time that it so carry on business is jointly and severally liable for the payment of all the debts and liabilities of the company incurred during that period. Meaning that a company should have a member at all times. If you don't have a member and you continue to work and a company carry losses, incur losses, the directors are going to bear the cost. So that is point one. Another point, look at section 171. 171. So right, section 171. When I send it to you, then you can capture it well. So 171, subsection 1 and 2. Ordinarily, a company is required to have at least 2 directors. Now, if a company at any time, the number of its directors is less than 2, and the company continues to carry on business for more than 4 weeks, at that time, the company, the directors, and each member of the company that is in default is liable to pay to the registrar an administrative penalty of 20 penalty units for each day during which the company so carries on business after the expiration of the 4 weeks without having at least 2 directors. So you are required to have 2 directors at any point in time. If you don't have, you have up to 4 weeks to find someone. If you fail to do that, you will be liable. So if you read the provision well, you will notice that what we have here is different from what is in your notes. So this one says if at any time the number of directors is less than 2 and the company continues to carry on business for more than 4 weeks, but if you check your own book, your book says that when a company carries on business for more than 6 months without any member, so here you are ratified to the effect that, so let me show it to you. So your first point says that a company carry on business for more than 6 months without a member. This point has been changed. So at least you should have a member at all times. So this one has been changed. For this one, when a company carries on business for more than 4 weeks, after the number of directors fall to, there shall be penalty units. So this one is the same. So the second point is the same, but the first point has been changed. So that is it. Let's move to another point. Look at section 125. 125, let's go. 125. Section 125, you write it down. Section 125, write it down. So I'm moving you back to section 125 and see what is there. One, two, five. So 1252. 1252. No matter what you are required to do is that, when are you closing? Hello?
I think 1:30.
1:30, okay.
Yeah. It's 1:30. We have a break before the 2 o'clock.
Yeah, no problem. From the look of things, we will schedule a time again for the rest of the discussion. Now, a company is required to write its name boldly on its walls. If you fail to do so, section 1252 says that you will be personally, the officers who fail to ensure that the name of the company has been written boldly will be liable. So that is section 1252. That one is what is your manual is correct. So you may use that point. So point A is not correct. Point B is correct. Point C is also correct. Just that the numbers are not the same. So point D2 is correct. Point E is also correct. Point F is also correct. Point G, cancel. Point H is not correct, also cancel. Point G, point H, point A. Those points cancel from your book. Don't read it. They are not relevant now. You get it?
Yes, sir.
Yes, sir.
Point
Yes,
A,
yes.
point A, point G, point H, cancel. They are no more relevant.
What about the
Okay.
what about the I?
Aye.
I've asked you to cancel some things. I've not asked you to cancel something. So cancel what I've asked you to cancel. And let's proceed. Now,
Okay.
the I is still valid. The I point the fact that for complemented by, so the I can now be found. The point I, we are saying that for a complemented by guarantee, we know that it is not meant for carrying on business for the purpose of making profit, but the profit that we get is for the furtherance of its objects. Now, if you carry on a company limited by guarantee as if it's a company registered by shares, you will be responsible, you will be charged, you will bear the liabilities. So the I is also correct. So maintain that one, but you can find that one in section 8.2 of the Act. Now, lifting the Act by other legislation, what we mean is that sometimes other laws will also require that the veil must be lifted. So in that case, you look at the Income Tax Act. The Income Tax Act knows that the Income Tax Act 592 is no more. So what you have to write is this one. Don't worry, you are going through this. It's not my fault, it's not your fault, but you'll be fine. Now let's look at the very point. The very point that you are seeing in your manual. The point is correct, but the section there is wrong. So you can say that where the Commissioner General is satisfied that a company controlled by not more than 5 persons and the associates does not distribute to its shareholders as dividends a reasonable part of its income from all sources for a basis period within a reasonable time after the end of the period, the Commissioner General may, by writing, notice in writing, treat that part of the income of the company which the Commissioner General determines as distributed as dividends paid to its shareholders during that period or any other period. What this means that when you declare dividends, it is subject to tax. So if you don't pay dividends, why you have to pay? And the company, the members, the ones who control the company are not more than 5. The Commissioner General will take portion of your income and place tax on it so that you pay. So that is it. We have other laws as well. When you are, so this point, the first point is also correct, just that the law that has been attached is wrong. Now, if in the course of winding up, it comes that your company was formed with the intent to defraud at creditors, you will be responsible. So, under the lifting the veil by other legislation, the point there are correct. By the sections or the acts they have put there, they are all old acts. But the new act, the content is the same. So you maintain it. Now, lifting the veil by the courts. So you are looking at instances in which the court will lift the veil, will ask that the individual members should be responsible, not the company. And for this session, everything in the book is intact. So Instances in which the court will lift the veil is: 1. If the court is certified that the company is the alter ego of a particular person. When you use the company as a sham, as a scam, the veil will be lifted and see who is behind the whole act. When you conduct improper business, willful misdeed, to defraud, avoid a scheme to evade contractual obligation, you negotiate a contract for yourself but not for the benefit of the company. All these instances, the veil will be lifted by the courts. I'll pause here and take few questions before I will go to the ultra virus. Any question for me? Is there any question for me?
No,
Hello?
sir.
No.
So let's go to ultra virus. Now,
No,
ultra
ma'am. No,
virus
sir.
is very simple. When you talk about ultra virus, it's very simple. Now, ultra virus means that you have gone beyond your object of incorporation. Now, I indicated that as a company, you may not have constitution. But if you decide to have a constitution and you state the business that you are going to do, then you cannot go beyond the business that you have stated. So if you say that you're going to sell pepper in your constitution, you cannot add selling of phones or tomatoes, because that is what you have mentioned. You go according to what you have done. Ultra virus also means that the powers that the company and its officers, they have gone beyond it. So you have to operate within your powers. So when you fail, you operate beyond your powers as a company or officer, you say you have acted ultra virus. Or if you do something which is not in your constitution, you have done what is, it means that you have acted ultra virus. Now, when you are reading your book, when you see regulation, you change it to constitution. When you are reading your book and you see regulation, you change it to constitution. So that is it. Now, what is the position of the law on ultra virus? Now, in the case of Bank of West Africa versus Appleton, the court held that anything which may be regarded as incidental to or consequence upon the main object specified in the memorandum or regulation, now the constitution of the company, may, unless expressly prohibited, be regarded as intra-virus. So if the act is incidental to the main object of the company, then it is ultra-virus, it is intra-virus but not ultra-virus, unless there's a statement that you cannot do that act. What are the remedies if someone is acting ultra-virus? What are the remedies? 1, a member or debenture holder secured by floating charge may apply to the court for injunction to prohibit the person from acting or set aside that performance and even seek for compensation. Now, the point is that these remedies are also valid, except that the sections that are attached to it, they are no more the same. It has been shifted, but the content is the same. So you may stick to the content and leave the sections. So basically, that is for continuation of unit 2. Continuation of unit 2. The business for the day we are now about to start. Hello.
Yes, sir.
Yes, sir.
So technically, the business of today is company membership and directors.
Okay.
But because we are having outstanding, are you going for a break before you write the quiz, or you have another week before you write the quiz?
I think the quiz is after next week.
The quiz is next week.
After next week.
21st. Next 2 weeks.
21st, yeah.
21st. It means that next week you will meet, right?
Yes, please.
Yes,
Next week is what, please?
a break.
Revision.
Next week is break.
Revision.
Is that the case?
I think
As we-
Yes.
revision.
Next revision.
Revision.
So next week we are not meeting.
Yes.
Yes, please.
Is that the case?
Yes.
Yes, it is.
Yeah.
I am seeing that the majority are saying yes.
Oh, but I think we can still the meeting and meet.
We are following what's on the time.
But since you are not done, I think it's a nice idea. Is we all agree to meet, so I feel will take us through. Because looking at what we are doing,
Yeah, you
most
will
of the
meet.
things are most of the things are outmoded. So I still will enlighten us with the current one.
Yeah,
So as we all decided
you will go
not to
through.
make mistakes.
So
Sure.
today we have 27 minutes. We will do the letter that we can do. When it is time, then we close and we agree on different dates. Probably either Monday will do. Monday or Monday can be okay.
Yes.
Then you schedule a time. Then you,
Hello, sir.
yes.
Yes, please. Monday, is it in the evening? We have.
Now, apart from evening, will you get time for the day?
No, sir.
Oh, please. If that will come before maybe 6, because from 6, some of us are having a course on Sunday and Monday.
But do I have class with you tomorrow?
No, please.
But this class is 3
Fine.
credits
It's
hours.
Tuesday. Yeah.
This is
So
I'm listening. This class is 3
Yeah, I think
hours,
we
so
said
where is the 1
Tuesday.
hour? Wait. This class is 3 hours, so where is the 1 hour?
Sir, I don't know
on
how
the
they did
timetable,
that.
it's only 2
Because
hours. The timetable is only 2 hours.
I think that the 1 hour, they are left for us to fix it on a page that should be comfortable. So tomorrow,
So as we did
Can we
last
fix
week, I
it
think
today?
Tuesdays, the agreed date
please,
that we all met last week.
Sunday.
So if that will be possible again.
Wait, Sunday, can you find a time for me?
yeah, Sunday evening will also be nice.
Sunday there's class.
Sunday we have
Class
to have
on
class.
Yeah, we have class.
Sunday we have a class.
We have class, so.
Wednesday will be good.
Yeah, we have a class
Wednesday
on
will be
Sunday.
good.
MIN.
Please,
You let me finish
please,
what
what
I'm
of
teaching.
Wednesday?
Let me finish what I'm
Wednesday,
teaching.
it's not about
Wednesday will
class.
be good.
We can
We can leave it
Wednesday,
until Tuesday.
Wednesday.
Last week we met
It's
Tuesday.
okay.
So
No,
It's okay.
it's
let's
okay
do
for
tomorrow
Tuesday.
evening.
I beg, it's okay. Allow me to
We have
teach. When you
class.
finish, we talk about that one. If I allow you, not allow me to teach. Let's proceed. Membership of a company. You can find this under section 33 of the new act. Membership of a company. There are 3 ways in which you can become a member. 1, by being subscribed to the Constitution. By being subscribed to the Constitution. I've told you that wherever you see regulation in your book, write Constitution. By being subscribed to the Constitution. 2, by agreements. You may agree with the company to become a member. And while the company has shares, you can buy shares to become a member. So these are the 3 ways in which you can become a member of a company. Now, when you become a member, you may have rights and liabilities. you may have rights and liabilities. We have personal rights and collective rights. The personal rights of members is owned to the individual members personally, in their personal capacity. For instance, the right to receive notices, the right to attend meetings, the right to speak at a meeting. Please, can you hear me? Hello?
Yes, please.
So the personal right to receive proper notice when there's a meeting. Ask one of you when there was a meeting for Tuesday, he didn't get it, so he believed that his right has infringed upon. Right to receive proper notice. Right to attend general meeting and appoint proxy. You will discuss proxy later. Yes, the proxy simply means that the person that you appoint to attend the meeting on your behalf. Right to speak at a general meeting. When you go to meeting, you have the right to speak. Right to vote on any resolution. So when there is a decision you have to make, you have to vote. Have your name and your shareholding entered in the register of members and ensure that unauthorized people are added. You also have the right to receive dividends when declared and paid. So when the company declares dividends returns, you are entitled to receive your portion. Preemption rights. If you are a private company, when there's an available shares, they have to give you the right to decide whether you will buy or you will not buy. Inspect members register. In fact, there are a lot. So you look at them. Now, members liability. Once you have liability, you have what? Once you have rights, you have liabilities. So it's like the fine boy who decided to go for a fine girl. You know the liability associated with it. Hello?
Exactly.
Yes,
madam.
once you are enjoying the benefit, you also have to pay the expenses.
Yes.
So that the woman will be on top, like as you saw her first. So it is not the benefit that you enjoy, there's also liability that you have to pay. It's the same thing like company.
Some boy.
Come again.
What of an ugly lady going for a handsome guy?
And that one, there's also a price to pay. You have your rights, the enjoyment, and the costs.
Okay.
Now, liabilities. Prior to the winding up, members are liable to contribute the balance on the amount payable. So before the company is brought to an end, the members must contribute to the outstanding balance, especially if you are owing. In the event that the winding up past members are liable, if the winding up occurs within 1 month, 1 year, you have to call them. So if the company started winding up 1 year after you have ceased to be a member, you can be called upon to contribute for the losses that the company is facing. Now, how do you cease to be a member? When there's a valid transfer of shares and it is registered by the company. Now, operationalization of law, when the government decides to rationalize certain companies, the state will take over. You cease to be a member. Forfeiture of shares for non-payment of costs, meaning that shares have been issued to you, but you have not paid, so they have taken their shares back. When you die, that is the end. When you die, that is the end. So that is under membership of a company. Very short one. The next topic that we shall treat is the register of members and company meetings. So under this one too, the information there is intact, save that or accept that the numbers there are not correct now, but the content is okay. Now, when it comes to register of members, we are saying that every company should have register of members. Like when you were in class 2, you have school register, your name will be written there, they will be marking you. The kubolos, absent, absent, absent. So the register should contain the names and address of the members, a statement of the shares held by each member and share numbers, the amount that you have paid, the amount that you are owing, the date your name was entered, and the date you cease to be a member. So that is it. If you are more than 50 members, you will be given index numbers. So it will make it easy. The act ensures that the public get access to various documents and they can inspect. And you are required that in every day working day at least 2 hours. General meeting, class meeting. Now, general meeting is for the whole members. Class meeting is for a particular class of the company. So when there's a class meeting, you cannot attend the meeting if you're not a member of the class. Now, the general meeting, we have 2 types. We have annual general meeting and extraordinary general meeting. Now, we talk about annual general meeting. As the name suggests, the company is required to have annual general meeting every year, once every year. Now, if you form your business your first annual general meeting is required to be within the first 18 months of incorporation. Meaning that if you form your company this year, you have 18 months in which you have to organize your annual general meeting. Now, the interval between 2 annual general meetings should not be more than 15 months. So if you pick 2 ordinary annual general meetings, then the interval there should not be more than 15 months. So that is it. Now, when you have annual general meeting, you have to send the statement of financial position, the comprehensive income. The old time used to call it profit and loss account and balance sheet. You have changed the name. The accounting student, are you aware? The profit and loss account is now called the income statement.
Yes, please.
The balance sheet is now called the financial statement. Statement of financial position, yes. Statement of financial position. So in your manual, you have to change these things. So I hope you agree with me.
Yes, sir.
Yes.
Sir.
But the rest are the same. And any group account, director's report, auditor's report, you have to send in there. Now, you should also note that when we are doing with annual general meeting and we make reference to ordinary business, these are the things that we are talking about. The declaration of dividends, the account and directors and auditors reports, election of directors to replace those who are retiring, fixing the remuneration of auditors, removing and electing auditors and directors, or auditor and directors in accordance with the law. So when you hear ordinary business, these are the things that you are making reference to. Now, I made mention that there are two types of general meetings: annual general meeting and extraordinary general meeting. Now, we said the annual general meeting is held every year, and there are rules applicable to that meeting. For ordinary meeting, any meeting apart from the general meeting, annual general meeting, is an extraordinary general meeting. And these are the meetings that requires the addressing of urgent matters, that we cannot wait till the next annual general meeting before you can meet. So for instance, when your competitor is bringing new products in the market, you quickly organize an extraordinary general meeting to find solution to compete with your competitors. I hope you get it. Now, whether you are a private company or a public company,
yes, sir. Yes, sir.
You have your own rules. Now, when it's come to private companies, you can this is the directors who have to convey the ordinary general meeting. If they fail, then members, two or more members, or if you're a single member, you should have at least 10% of the shares. You can requisition or call for the extraordinary general meeting. You state the nature of the business to be transacted, and you serve the company. When the company receives the letter, the directors have 7 days to fix a meeting within 28 days. And if they fail to fix the meeting, you, the one who requested the meeting, can organize the meeting, and if you incur any losses, the directors will pay, or the company will pay, and the company will take it from the directors. When they fail to organize, you have 4 months to convey the meeting. However, if it is an extraordinary general meeting for public companies, then you need at least 5% of the shares of the company. You state the nature of the business, and you send you sign and you send it to the office of the company. Within 28 days after they have received, they have to proceed to fix a date within another 28 days. If they fail to do that, the one who requisitioned or requested for the meeting can organize a meeting within 4 months, and the expenses will be paid by the company, and the company will later charge the individual directors who fail to do so. So basically, that is it for session 2. I'll pause here and take a few questions. Other than that, I shall proceed. But I don't know whether you will give me a chance to continue, and I don't have to, because the next topic is lengthy. I don't want to rush through.
Yes.
So, are you going to give me time, or we should close and come back later? The rest of my topic are lengthy. I can't rush you.
We should close and come back later.
Okay.
Yeah, we want to eat. Come later.
Okay. So when we come back, we will continue from unit 3, session 3.
What time? What time?
When do you want us to meet? Can we meet tomorrow?
No, sir,
Tuesday
is fine. Say the Tuesday is fine.
Tomorrow
Tuesday is fine.
Tuesday is fine.
Tuesday is fine.
Tomorrow we have classes.
I beg, Tuesday we have class.
Tuesday,
You
you
start
Tuesday we have
class.
class.
Tuesday we have class.
Tuesday we have class.
So when are you free?
The finance student, Tuesday we have class.
Wednesday.
So let's see
When are you
tomorrow
free?
evening, if only to possible.
No, tomorrow we also have class.
Tomorrow we have
What about
class.
Wednesday? What about Wednesday? Wednesday.
It on the WhatsApp page.
This evening can
Let's
even
we
be
can
this
find
evening.
a day.
This evening.
We have
Come again.
This evening.
Let's discuss it in the WhatsApp
Okay.
so that we can
This
get
evening
it.
too is better. So let's discuss it on the WhatsApp platform. The WhatsApp platform, we say that I will get the people, others will not come. So
I will be expecting your feedback.
from today evening is better for me.
Evening to some of us have
Not for you, Yamini.
They have
our
We have class in the evening.
So please go and discuss and give me feedback.
That will be fine.
Please go and discuss and give me feedback, okay?
Okay, sir.
Matilda,
Yes.
lead the discussion and give me feedback by close of the day.
Okay, sir.
Okay, thank you.
Come, sir.
Welcome.
Matilda, can you send me your WhatsApp, email? Okay, let me see if I can send that out to your phone and share with you.
Okay, sir.
Class, let's have the date. Let's have the date, the time. That will be convenient for all of us.
Okay. What do you suggest?